One of the most common questions I get from prospective clients is, can I file an I-130 petition for my family member? Or who can file an I-130 petition for me? If you have that question and you're wondering the ins and outs about I-130 family petitions, watch this video. Hi, I'm Cecily Clements, founder of Root Migration. I help undocumented individuals achieve lawful status through consular processing without fear or confusion. I speak fluent Spanish, so the majority of my cases and clients come from Latin America. The information in this video is general in nature and does not pertain to your particular case. If you have specific questions about your particular case, I highly recommend that you consult with a competent immigration attorney. So I'm going to be giving very general overview information to help give you an understanding, but it's really ideal that you work with an attorney on your specific case. Okay, so there are two categories of individuals that can file I-130s, and that's the petition for alien relative I-130 in the United States. The first category of individuals is United States citizens. The second category of individuals is lawful permanent residents. A United States citizen is anyone who was born in the United States, and also anyone else who's gone through the complete immigration process. So they were born in another country, they obtained some sort of status here in the United States, and then they applied for citizenship. Applying for citizenship is a process called naturalization. You fill out a form, you go to an interview, you take a test, and then you become a citizen of the United States. A lawful permanent resident is the same as what people often call a green card holder. Lawful permanent residents have the right to permanently live and work in the United States. It's a very powerful immigration status in the US. It's basically right below being a citizen of the United States. Lawful permanent residents can travel in and out of the country, in and out of the US. They do need to be careful. They can't be out of the country for too long. And certain criminal convictions can be a problem for green card holders or lawful permanent residents when they travel. So it's not completely unrestricted. There are differences between being a citizen and a lawful permanent resident, but a lawful permanent resident is a very, very high and powerful status in the United States. And both categories of individuals, US citizens and lawful permanent residents, are eligible to file I-130 petitions on behalf of their family members. So in this video, I'm going to talk about 5 different types of I-130 petitions, or different categories of I-130 petitions. The very first one is what we call immediate relative petitions. Those are filed by United States citizens for very specific people, and I'll go into some detail a little bit later in the video, but they really are the most powerful petitions that a person can file. They give the most benefit to the beneficiary. The remaining 4 categories of petitions that I'm going to talk about are what we call preference petitions, or preference category petitions. And there's 4 different preference categories. There's first preference, second preference, third preference, and fourth preference. Not very imaginative names, but that's how they go. And I'll go through each preference category one by one, but basically those preference category petitions don't have the same power, frankly, as an immediate relative petition. They take longer and they don't afford some of the same processes and rights that the beneficiary of an immediate relative petition enjoys. Okay, so let's get into the specifics of an immediate relative petition. So like I said, to file an immediate relative petition, you have to be a United States citizen. So the petitioner has to be a citizen of the US. It doesn't matter whether they were born in the US or they became a citizen through naturalization. It's all the same. If they're a citizen of the US, they can do an immediate relative petition. Now, the only people that a US citizen can file an immediate relative petition for are 3 types of individuals. One is their spouse. The next category is their child, and child has a very specific definition in immigration law. Their child who's under the age of 21 and who's not married. If a US citizen has a child that's 19 or 20, but they're married, then they're no longer considered an immediate relative of that citizen parent. And child is obviously biological child, but it also could be an adopted relationship. There are very specific requirements for an adopted relationship that I'm not going to go into this video, but it is possible if you meet those requirements. And it can also be a stepchild. If it's the stepchild, the marriage between the citizen of the United States and the biological parent had to have happened before the stepchild was 18, but then the citizen step parent So long as the marriage occurred before the stepchild was 18, the citizen step-parent can file a petition, an immediate relative petition, on behalf of their stepchild up until the stepchild is age 21, unless, of course, they get married under, at any point they get married, they're no longer in the immediate relative category. So it's complicated, but that's kind of the permutations of the child category. Citizens of the United States can also file I-130 petitions for their parents. The citizen themselves has to be has to be 21 years or older, and then they can file a petition for their parents. In that context, it doesn't matter if the citizen is married. The citizen can be married to a person, and they can still file a petition for their mom or dad. But the citizen who's filing the petition has to be over the 21 years of age or older. And so that's also an immediate relative petition. So again, it's spouse, child, parent are the basic three categories that a citizen can file an immediate relative petition. In order to properly explain the 4 preference categories for I-130 petitions, I'm going to show you what's called the Visa Bulletin. The Visa Bulletin is published every month by the United States government. It shows the backlogs and the preference dates that are currently eligible to apply for a visa. The immediate relative category, the one that I just talked about with United States citizens being able to apply for their spouses, their parents, and their children, there is no backlog. Once the I-130 petition is approved, the beneficiary of an immediate relative petition can immediately apply for their visa. So they don't have to wait any period of time for a visa to become available. A visa, the way we talk about it in immigration law is the visa is immediately available. In the other 4 categories or preference categories, visas are not immediately available. Even when the I-130 is approved, there's still like a time period that the beneficiary has to wait for the visa to become available. And the way they know that the visa is available is they go to the Visa Bulletin, which is what I'm going to show you in a minute. The other piece of information that you need to know in order to know whether there's a visa available for you is your petition preference date. And that is usually the date that your I-130 petition was filed with immigration. And it's listed on the receipt notice and on the approval notice. So I'm going to turn to my computer in a minute and we're going to go through this step by step, showing you these specific documents. Okay, so this is what we call the Visa Bulletin. You can honestly just go to Google and type in Visa Bulletin. It's updated every month by the Department of State. You can see there's different months here that you can look at. So we can go to the most recent one, which is the April 2024. You can download a PDF or you can just look at it on the screen. And so this is where, for those people who are beneficiaries of petitions that are not immediate relative petitions, where they fall into one of the 4 preference categories, this is where they can come to find out an approximate idea of how much longer they have to wait for a visa to become available in their case. It's important to note that the Visa Bulletin does track both family-sponsored preference categories as well as employment-based preference categories. Now, in this YouTube channel, I don't really deal with employment-based. I don't do employment-based in my law firm. So we won't be going over the employment-based today, but that information is there on the Visa Bulletin as well. Here's the family-sponsored preferences. And as I said, there are 4 categories. There's first, second, third, and fourth. This second preference category is broken into 2 subcategories, which is F2A and F2B, and I'll talk about that in a minute. The first preference category is unmarried sons and daughters of U.S. citizens. Like the term child, the terms sons and daughters has a very specific definition in immigration law. So you are a child in immigration law if you are under the age of 21 and unmarried. So if at any point before you're age 21, if you get married, you no longer qualify as a child for purposes of immigration law. If you're 21 or older, you are not a child. And so then you become a son and daughter or daughter. Okay, so that's the opposite. Sons and daughters are like children of, the petitioner, but who don't qualify as a quote unquote child according to the definition of the immigration laws. So if you're a son or a daughter, that means you're married or you're over the age of 21, married or unmarried. So the first preference petition is for unmarried sons and daughters of U.S. citizens. So this means people who are not married, but they're 21 years or older, and their parent, the person who's eligible to petition for them, is a citizen of the United States. Okay, so that's the first preference category. This second preference category is for lawful permanent residents. The second preference is the only one where it's lawful permanent residents who are the petitioner. F2A category is for spouses and children of permanent residents. So again, you see that word children. It has a very specific definition. You must be under the age of 21. Qualify as the beneficiary of an F2A petition. You'll notice F2B is unmarried sons and daughters. So here again, we're talking about people over the age of 21 who are unmarried. It's important to note there is no category for married children or sons and daughters. Now I'm just using those terms in the normal English language. There's no category for married children of lawful permanent residents. So if your petitioner is a lawful permanent resident, like it's your mom or your dad, and they're a green card holder and you're married, they cannot petition for you. Or if they petitioned for you a long, long time ago and you've been waiting around for your visa and then you get married, then you've lost the petition. A lot of people find themselves in this category that they have this petition that their parent filed for them many years ago. So they're just like not getting married because they want to keep the petition alive. So that's really important to note about the second preference petition. It's the only category of petition where the petitioner can be a lawful permanent resident, and it's only for spouses and kids that are unmarried. And the kid can be older than 21. That would put them in the F2B category, but they cannot be married. If it's a spouse and a kid under the age of 21, then it's the F2A category. Then we talk about the third preference category right down here, and it says married, it's married sons and daughters of U.S. citizens. So now we're back to U.S. citizens being the petitioner, and it's sons and daughters, which means they're over the 21 years of age or older, but now they can be married. So that's one of the key differences between when we're talking about the preference categories. It's a citizen who's the petitioner. The son or the daughter can be married, unlike if it's a lawful permanent resident. But if they're married, they're going to go from the first preference category down to the third. And then the fourth preference category is brothers and sisters of U.S. citizens, siblings, obviously, right? That's in the very last fourth category. So those are the category preferences in the Visa Bulletin. Now, I will do another video that goes even more into depth into the Visa Bulletin, but I'm just going to show it briefly here. These are all the categories broken out, and these are what we call the preference dates. If I reference an I-130 approval notice, and this is also on the receipt notice, you will see here that, let me just get closer, there is what's called a priority date right here. So for this particular petition, it was September 6th, 2022, which is also the date that it was filed. And that's really common. You're going to see the priority date and the date filed matching. Sometimes that doesn't happen, but for the most part, it really does. Okay, so that's where you know what your priority date is. And here is also where they tell you what the preference category is. So this is parent of a U.S. citizen. So this is actually an immediate relative petition. So we didn't need to worry about the preference categories. Let's just say it was for a different category. Let's say it was for, unmarried adult children of a USC and of a United States citizen, and the priority date is September 6th, 2022. If we come to the Visa Bulletin, you can look here. Let's say it was this category, F1 category, and you can see what dates this category is at, and you can further see it depends on what country the beneficiary is from. So let's say it was a family first preference category. So again, that's unmarried sons and daughters of U.S. citizens. This is where you can see what date your priority date needs to be at in order for you to be eligible to apply for a visa. And you can see that there is some distinction among countries based on the amount of individuals that immigrate from those countries. So some countries will be more backlogged than others. And that's just the way you do it. You look at your priority date for the petition that was filed for you. You look at where you fall onto this chart. Are you a first preference? Are you a second preference, A or B? Are you a third preference or a fourth preference? And then do you fall into one of these categories of countries that has different dates specified, or are you just from a country that isn't one of these four? And you look at the date that is current. What this means right now is for anybody who had a first preference petition filed by their parent, So that again, the parent is a United States citizen. They, as the beneficiary, are unmarried and they're over the age of 21. If their petition was filed on February 8th, 2015 or earlier, so if it was filed on February 7th of 2015, January of 2015, November of 2014, and on and on and on, now they're eligible to go apply for their visa at the consulate. You can see that there's quite a backlog for a number of categories. This is from 2000, and we're right now in 2024. So you're talking about 24 years, basically, give or take, for fourth preference category. That's brothers and sisters of adult citizens, if the beneficiary is from Mexico. So that's how you sort of read the visa bulletin. It's not literal. Don't think that each month these dates update by exactly a month. And so it will be however many years based on these dates. These dates fluctuate all the time. They go forward, they move back. It depends on who's actually immigrating, coming to the United States. The government keeps track of all of these things. And that's how you can tell where you're at with your priority date. Once again, there's a category all by itself, all alone, that isn't even on the visa bulletin because there is no backlog, there is no quote unquote wait time. And that's the immediate relative petition. That's filed by United States citizens for their spouses, their children, and their parents. You know, there is a delay, obviously, for the petition to be approved. The petition itself takes about a year to be approved, but once the petition is approved, those individuals, the beneficiaries of an immediate relative petition, are immediately eligible to apply for their visa. Anybody else who falls outside of the immediate relative category, but who's still eligible for an I-130 petition, would fall into one of these preference categories, either first, second, third, or fourth. So once the petition is approved, they still have further waiting that they need to do for their priority date to become current, for a visa to become available. That's the two different ways we talk about it in immigration law. And the way you can tell that your priority date is current or that there's a visa available to you is by coming to the visa bulletin and checking this chart for your priority dates to see if your priority date has appeared or has been passed. And like I said, this visa bulletin is updated every month. Okay, so I hope you found that overview of the different preference categories helpful, just the general overview of the visa bulletin. If you have enjoyed the content of this video, please remember to hit subscribe and put a comment below and let me know if you're enjoying the videos, if you have any other ideas for videos, or if you have any questions about what I talked about today. Hit the notification button too to make sure that you get notified of any new updated videos. And don't forget, I've got some free resources below this video in the description. I have a PDF that goes over the steps to a consular processing case, and also a different PDF that talks about 6 things you must do to win your waiver if you are, needing a waiver in your case. So thanks so much for watching. I really appreciate it, and I'll see you in the next video.